6 single member LLC mistakes that will destroy your business. You filed your articles of organization. You got your EIN from the IRS, and you officially have LLC after your business name. You feel invincible. Your personal assets are protected, your house is safe, and you're a real business owner. But here is the scary truth. For a single member LLC, that limited liability shield is much thinner than you think. In fact, most solo entrepreneurs are making at least 2 to 3 mistakes right now that effectively void their legal protection. If you got sued, a lawyer can pierce the corporate veil, come for your personal savings, your car, your home, as if the LLC never existed. So today, I'm doing a deep dive into the 6 single member LLC mistakes that will hurt or even kill your business. Stick around, because mistake number 4 is something almost every lifestyle influencer and freelancer is doing right now without realizing it. My name is Leon Jones Jr., and for over 15 years, I've practiced in both state and federal courts here in Arkansas. I've worked for a Fortune 100 company and held positions of Director of the Arkansas Department of Labor and Executive Director of the Arkansas Fair Housing Commission. Now, I'm the Managing Attorney here at Big Rock Legacy Law Group, where we advise and represent our clients in business law, civil litigation, estate planning, and family law. Over these many years, I've had business owners deal with this very issue, and I hope this video helps provide some insight into how I provide my advice, which is different for every client. So mistake number 1, commingling funds, or the big pot error. Commingling is when you treat your bank account like a personal piggy bank. Let's say you're at Target. You buy office printer paper and a pack of diapers for your baby. You swipe the business debit card for the whole thing. Or you're short on rent, so you pay your landlord directly from your business PayPal account. So why does this hurt? The whole point of an LLC is to create a separate legal entity. If you don't treat the businesses as separate, a judge won't either. This is the easiest way for a creditor to pierce the corporate veil. So what's the fix? The church and state rule. Have a dedicated business checking account and credit card. If you need money for diapers, transfer an owner's draw from your business checking to your personal checking. Then you can buy the diapers. There it creates the paper trail, which is your armor. Mistake number 2, missing or generic operating agreements. You say, but I'm the only member. Why do I need a contract with myself? I hear this every day. Most states really don't require legally you to have a single member LLC operating agreement, so owners skip it. But it's a massive tactical error. So what's the problem? Without an operating agreement, your business is governed by your state's default LLC laws. These might not be favorable to you. More importantly, having an operating agreement proves to the courts and the IRS that your LLC is a formal, organized entity and not just a shell for your personal habits. Your operating agreement should state how the business is managed, what happens if you become incapacitated or die, which is your succession planning, and how capital is contributed. So what's the fix? Don't just download a $5 template. Ensure it specifically mentions single member provisions and clearly outlines that you are the sole decision maker. To learn more about how we assist our clients with these and other types of legal situations, click the link below and let's get started today. Mistake number 3, signing contracts as yourself. This is a subtle one, but it's where the legal shield often cracks. So let's say you're signing a lease for a small studio or a contract for a new client. The signature line says name, and you just write John Smith. What's wrong with this? If you sign your name without your title, you are often signing in your personal capacity. If the business fails to pay the lease, the landlord can sue John Smith personally because the contract doesn't show that the LLC was a party entering into the agreement. So what's the fix? Always sign your name like this: XYZ Business, LLC, signature, John Smith, title, managing member. Mistake number 4, improper, reasonable compensation. The social media influencers trap. If you have elected to be taxed as an S Corp, which many single member LLCs do to save on self-employment taxes, you have to pay yourself a salary. Owners often pay themselves a tiny salary, like $10,000, while they're making $90,000 in distributions to avoid payroll taxes. The IRS is aggressive about reasonable compensation. If they audit you and decide your salary should have been $50,000, They will hit you with back taxes, massive penalties, and interest that could wipe out your year's profit. Look at the Bureau of Labor Statistics data for your job title in the area in which you work and document why you chose the salary that you chose. Mistake number 5, neglecting state compliance. This is the silent killer. Many owners think that once the LLC is formed, they're done. But most states require an annual report and a statement of information. If you miss these deadline filings, even by a few months, your state can administratively dissolve your LLC. You might keep operating for a year without realizing your LLC doesn't exist legally anymore. During that time, you have zero liability protection. Put a recurring alert in your calendar for your state's filing deadline. Keep corporate minutes books, even as a solo owner, once a year. Write down a summary of the big decisions you made, buying equipment, taking out a loan. It adds a layer of formality that looks great in the courtroom if you get sued. Mistake number 6, inadequate business insurance. This is a safety net mistake. People don't think because I have an LLC, I don't need insurance. The truth is, an LLC protects your personal assets from business debts. It does not protect your business assets from business lawsuits. If someone trips in your office or sues your LLC for $500,000, your LLC's bank account, equipment, and inventory are all fair game. Furthermore, an LLC does not protect you from your own personal negligence. If you're a consultant or a lawyer and you give advice that costs a client millions, you can often be sued personally for malpractice regardless of the LLC. At a minimum, get general liability and professional liability insurance, E&O. It's often cheaper than you think, and it acts as your second wave fortress to protect you. Now let's look at a 3-step action plan that single member LLCs can follow, but requires discipline. Don't let the simple structure lead you to a lazy habit. So here's your homework for the week. Number 1, open that separate bank account if you already haven't done it. Number 2, check your Secretary of State's website to ensure your status is active or in good standing. And number 3, audit your last 3 contracts. Did you sign as the managing member or did you sign personally? If you want a checklist of these 6 mistakes, keep at your desk, send an email to info@brllg.com and put 6 LLC mistakes in the subject line along with your name and your business lane, and we'll send you the checklist. Navigating the legal world of running a business is just as essential as the products and services you offer. Protecting yourself means protecting your passion, your business, and your future. I encourage each of you to evaluate your situation early, discuss your unique needs with qualified professionals to secure the best possible outcomes. If you found this video helpful, please hit the like button, subscribe to our channel to learn more valuable information about how we here at Big Rock Legacy Law Group protect our clients' legacy and advocate for their rights.